Imagine you're standing at the checkout counter, local grocery store. You've just finished loading your bags, you grab the receipt, and you start scanning through the list.
Right.
And suddenly, you stop. You realize you've been charged for the exact same gallon of milk. Twice!
I'll be so annoyed.
Same brand, same barcode, same price. It's
Yeah.
frustrating, right? You would probably call the manager over immediately.
I think anyone would. That's a few bucks you're not getting back.
Exactly. Now, I want you to scale that feeling way, way up. Imagine the receipt isn't for groceries, but it's the General Appropriations Act, the national budget for the entire country.
Okay.
And the item isn't a gallon of milk. It's a 200 million peso road project. And the person accused of, punching in that double charge, not a cashier, the president of the Senate.
That is quite the visual. But, if we really want to make this analogy accurate to our source material today, we have to add a layer of just absolute chaos. Imagine the store managers start fighting so intensely over who gets to investigate the error that they effectively board up the complaints department, just lock the doors and refuse to let anyone in to fix it.
And that is exactly where we're going today. We are time traveling back to 2008 and 2009 to unpack a massive political and legal showdown in the Philippine Senate. We're looking at the infamous C5 road controversy, but we aren't just reading the headlines. We are digging into the rulebook itself.
Right. We're diving into a specific Supreme Court decision, GR No. 18771. It's a fascinating case because, well, while the corruption allegations were the spark, the real fire was about the mechanics of accountability.
So what happens when the people who make the laws break the mechanism designed to discipline them?
That's the question.
This is a story about a double insertion, a paralyzed committee, and a Supreme Court that had to step in as the ultimate referee. So get comfortable because, okay, let's unpack this.
To understand the legal chess match that ended up in the Supreme Court, we first have to understand the spark, the accusations. It all kicked off in September 2008.
I was looking at the notes on Senator Panfilo Lacson's privilege speech. He titled it Bantayan, which, translates to guard the public coffers.
It's a pretty strong title.
It was. And he didn't just make vague accusations, he brought receipts. I mean, literally. He pointed to the 2008 budget and found two specific entries.
And this is where the double insertion term comes from.
Right. Item 1, an appropriation of 200 million pesos for the President Carlos P. Garcia Avenue extension. Item 2, another 200 million pesos for the C5 road extension.
And for any of you listeners who aren't navigating Metro Manila traffic every day, Laxon's big reveal was that President Carlos P. Garcia Avenue is C5.
They're just different names for the same road. And the project descriptions were practically identical. Both were for the stretch from the South Luzon Expressway to Sucat Road in Parañaque City. So Lacson asks the obvious question, why are we paying for the same stretch of road twice?
And the investigation trail he laid out, it led straight to the then Senate President, Manuel Villar.
But if you look at the source material, specifically Senate Resolution 706 from Senator Madrigal, the allegations went way deeper than just a budgeting error. This wasn't just about the road, it was about where the road was going.
Ah, okay. The conflict of interest part.
That's it. The resolution alleged that Villar used his influence to realign the road project. So instead of going where it was originally planned, the accusation was that he diverted it to pass specifically through his own properties.
And Parañaque, right. Barangay San Inicio and Pulang Lupa, I believe.
To be exact. And the economic implication, of course, is that if a major government highway suddenly runs through your backyard, well,
your property value skyrockets.
And it gets even bolder. The resolution also claimed that his corporations then sold the road rights of way back to the government at grossly overpriced rates.
So the allegation is really a trifecta. You move the road to hit your land, you make the government pay a premium to buy that land from you, and then you budget the construction twice.
Wild.
Of course, we have to state, Villar vehemently denied all of this. He argued his properties were acquired long before the project and that the road was for public benefit. But in the Senate, when you accuse a member, especially the Senate president, of something this serious, there's a specific playbook.
Right. You don't just tweet about it, or back then, I guess, post it on Facebook. It goes to a specific group, the Committee on Ethics and Privileges.
That is the standard procedure. The Ethics Committee is the disciplinarian. They investigate, they hold hearings, and they recommend a penalty. But this is where the story shifts from a corruption scandal to, well, a procedural nightmare.
Because in November 2008, the political winds shifted. There was a leadership coup. Juan Ponce Enrile became the new Senate president.
And consequently, the committees were reorganized.
And guess who became the chairman of the Ethics Committee?
Let me guess.
Senator Laxon.
The very man who exposed the double insertion. So you have the accuser now sitting as the judge.
And that, predictably, triggered a massive standoff. The Senate minority, the group allied with Senator Villar, refused to play ball.
They called it a kangaroo court.
Exactly. They argued that with Laxon as chair, the committee was just designed to destroy Villar's presidential ambitions for the 2010 election.
I'm looking at the correspondence here between Laxon and Senator Pimentel, who was the minority leader. It's incredibly tense. Laxon keeps asking, give us your members so we can start the hearings. And Pimentel basically just says no.
It was a strike. The Ethics Committee rules are very specific. You need members from both the majority and the minority to function.
So by refusing to nominate anyone,
They paralyzed it. They completely paralyzed the committee. It's a brilliant, if frustrating, tactic. If we don't show up, you can't try us. Senator Villar even publicly stated he wouldn't face the Ethics Committee. He said he would only answer the accusations on the Senate floor in front of everyone.
So the Senate leadership was stuck. They had these serious allegations, a paralyzed ethics committee, and a clock ticking. They had to pivot.
And pivot they did. Senator Laxon made a motion. He said, fine, if the Ethics Committee can't do it because the minority is boycotting, let's just transfer the investigation to the Committee of the Whole.
For you, the listener, the Committee of the Whole is a legislative device. It is exactly what it sounds like. Instead of a small group of 7 senators investigating.
The entire Senate acts as one giant committee.
The logic being, you can't boycott the committee if you are the committee.
Exactly. So the motion was put to a vote, 10 in favor, 0 against, 5 abstentions. The investigation was moved.
Now, you would think Villar would be happy about this.
Right. He said he wanted to answer on the floor. But here's where it gets really interesting. His allies sued to stop it.
And this brings us to the core of the Supreme Court case. The petitioners, Senators Pimentel, Villar, Joker Arroyo, Pangilinan, and the Cayetanos, they filed a petition for prohibition. They wanted the Supreme Court to tell the Senate, stop, you cannot do this.
Their arguments were heavy. They claimed this transfer violated equal protection. Basically, why was Villar being singled out for this extraordinary treatment?
Why wasn't he getting the normal ethics committee process like everyone else? And they also argued that the rules being used violated due process. But before the Supreme Court could even look at how the investigation was being run, they had to answer a fundamental constitutional question.
Can they even intervene?
Can they even intervene? Right. Separation of powers. We have the executive, the legislative, and the judiciary. They're supposed to stay in their own lanes. The Supreme Court isn't supposed to tell the Senate how to tie his shoes.
Generally, no.
Generally, yes, that's the case. The court acknowledged that the Senate has the power to make its own rules. However, and this is a big however, the court clarified that it can step in if there's a grave abuse of discretion or if constitutional rights are being violated.
So they rejected the political question argument.
They did. They said, no, if you break the Constitution while making your rules, we're blowing the whistle.
So let's get to the ruling. Did the court think the transfer to the Committee of the Whole was unfair?
No. The court actually ruled in favor of the Senate leadership on this specific point. They said the transfer was valid.
Really? Even though it was a deviation from the norm?
The court called it an extraordinary remedy, but they noted that the situation necessitated it. The minority had refused to participate. They created the deadlock. The court basically said you can't paralyze the Ethics Committee by refusing to join it and then turn around and complain when the Senate finds a workaround.
That makes perfect sense. It's like jamming the door shut and then suing the landlord for climbing through the window to fix the leak.
Precisely. And the court also pointed out a bit of irony. Since Villar himself said he wanted to answer the charges on the Senate floor, moving it to the Committee of the Whole, actually.
Yeah.
Gave him that venue.
Huh. So the claim that his rights were violated by the transfer didn't hold water.
Not at all.
So at this point in the story, it looks like a slam dunk for the Senate leadership. The transfer is valid, the investigation can proceed, the double insertion will be investigated, but hold on.
And here comes the twist.
Yeah.
And it is a twist that every law student just loves because it is so incredibly technical.
The Supreme Court looked at the fine print, and I mean the really fine print. The Committee of the Whole needed rules to govern the investigation, right? You can't just walk in and start shouting.
Right. You need rules on questioning witnesses, handling evidence, that sort of thing. So, to save time, the Committee of the Whole simply adopted the existing rules of the Ethics Committee. They said, let's just use these. They work.
Seems efficient. Why write new rules when you've got a perfectly good rule book sitting right there?
Well, the problem was in the details of those rules, specifically Section 81.
Section 81. What did it say?
It said, and I quote, "These rules shall be effective after publication in the official gazette or in a newspaper of general circulation."
Okay. And had the ethics committee rules been published?
Yes, the original ethics rules were published back in March 2009. But here's the catch. The Senate Committee of the Whole had not published their adoption of these rules.
Wait, so because they were technically a new committee, the Committee of the Whole, they had to publish the rules again, even though they were the exact same text that was already public.
That was the Senate's argument. They said, come on, everyone knows these rules. They're already out there. But the Supreme Court disagreed. They looked at the Constitution. Now, usually internal Senate rules don't need to be published unless they affect the rights of non-members. But the Senate's own rule, that Section 81 they adopted, said these don't work until published. The court essentially said, you wrote the rule. You have to follow it. You can't enforce a rule that says it needs publication without actually publishing it.
That is a classic gotcha. They tripped over their own shoelaces, they set a requirement for themselves, and then just ignored it because it was inconvenient.
It highlights a very important legal principle. Due process means following the procedure you set for yourself. If you say step A is publication, you can't just skip step A because you're in a hurry to catch a guy for a double insertion.
And it wasn't just the publication, was it? There's another copy-paste error that was maybe even more embarrassing.
Oh, the quorum issue. This one is quite stark.
So, okay, let's unpack this. They copied the Ethics Committee rules verbatim.
Okay.
Section 5B of those rules stated that a quorum, the minimum number of people needed to do business, was 2 members.
Which makes sense for the Ethics Committee. It only has 7 members. 2 is a reasonable number to get things started so you aren't waiting around all day.
But they applied this rule to the Committee of the Whole.
Exactly. The Supreme Court pointed out that for the Senate acting as a whole body, the Constitution, that's Article 6, Section 16.2, requires a majority of the Senate to constitute a quorum.
So by copying the rules blindly, they technically created a situation where just 2 senators could make decisions for the entire Senate.
Theoretically, yes. Now, the Senate argued, we know, we intended to use a majority. But the court said, that's not what you wrote down. You can't override the Constitution with a committee rule, even by accident.
That is a massive oversight. It really shows the danger of copy-pasting without reading. Sounds like something I would do on a term paper, not something the Senate should do on a major investigation.
It shows that in the rush to bypass the gridlock and get the investigation moving, they got sloppy with the procedural safeguards.
So what was the final verdict? Did the Supreme Court just shut it all down because of a typo?
Not entirely. It was a partial victory for both sides. The court ruled that the transfer to the Committee of the Whole was legal. The investigation could happen. The Senate does have the power to create this committee to solve the deadlock.
That's the big political win.
Yes. But the court granted the petition in part. They said you cannot proceed until you publish the rules and fix the quorum requirement.
So essentially, you're allowed to do this, but go fix your paperwork first.
Exactly. The ruling stated that the referral of the complaint would take effect only upon publication of the rules of the Senate Committee of the Whole. They hit the pause button, but they didn't unplug the machine.
It's a fascinating mix of, high political drama and really dry procedural compliance. You have the double insertion scandal, hundreds of millions of pesos, the boycott, the kangaroo court accusations, and in the end, everything pauses because someone didn't put an ad in the newspaper.
It sounds trivial, but for legal scholars, this is the system working properly. The court was reinforcing that even when you are chasing alleged corruption, you cannot cut corners on due process. The rules exist for a reason. If the Senate can ignore its own rules to investigate Viller, well, they could ignore them to investigate anyone.
So what does this all mean for us, for the learner listening to this?
I think it illustrates 2 things. First, the resilience of the system. When one mechanism failed, the Ethics Committee, the system found another way with the Committee of the Whole. It shows that institutions can adapt to obstruction.
And the second thing?
The supremacy of the rule of law. It didn't matter that it was the Senate president or the Senate majority involved. The Supreme Court stepped in to ensure that the internal rules were consistent with the Constitution and their own text. It's a reminder that no one is above the procedure.
It's also a great lesson in checking your work. If you say the rules need to be published, publish them.
Absolutely. The details matter.
So we started with a receipt for a road paid for twice, wandered through a political strike, and ended up with a lesson on constitutional quorums. That is quite the journey.
It is. The C5 controversy is often remembered for the corruption allegations, which, by the way, Viller continued to deny throughout the 2010 election campaign. But for legal scholars, it's this procedural battle that really stands out. It defined the limits of what a Senate majority can do to a minority and vice versa.
Before we sign off, here's something for you to chew on. We saw how the minority faction effectively paralyzed a disciplinary committee by simply refusing to sit on it.
Which forced the Senate to take extraordinary measures.
And that raises a provocative question for you, the listener. If a political faction can break the disciplinary system just by boycotting it, is the system itself flawed?
Right. Does our government actually have a reliable way to hold its own members accountable? Or does it always rely on the cooperation of the very people being investigated?
If the referees go on strike, does the game just end?
Or does it just turn into a free-for-all?
A scary thought to leave you with? Something to think about the next time you see a headline about a Senate investigation getting heated? Thank you for listening to this deep dive into the intersection of law, politics, and road construction.
It was a pleasure.
We'll catch you on the next one. Keep asking questions.